essentially judicial case management. Now, what was the role of the judge in the past? Probably the same thing you still do in the magistrate's court. The judge was a passive and a neutral umpire who acted on the prompting of the parties who alone, that is, the parties alone determined the pace and intensity of litigation. This led to a local legal culture characterized by delay and public dissatisfaction with the justice system. So the litigants really were the central focus of our system. We did what the litigants wanted. The litigants have started the case in court, but they don't want to go ahead. They want to indulge each other. They want to delay the matter for 6 months because one's lawyer is not available or for one or other reason. So we had become the hostages of the litigants. You had to sit and wait upon the litigants to tell you what to do with the case. That was our role as judges. Now, judicial case management is intended to reverse of civil litigation, recognizes a very fundamental factor, and that is that delivery of justice is a social service. Delivery of justice is subject to the same constraints as any other service provided by the state to the public. Now, why should delivery of justice be any different from, say, the government providing education or health services to the public? Those services are subject to considerations of budgets and finance. If the money is not there to pay the students' fees at the university, government will not pay it. Now, why should government grade a service, delivery of justice, where resources are considered to be limitless? That you can delay as much as you want, you can come and waste the taxpayers' money as much as you want, but it is not a consideration. Why should that be the case? And that was the problem with this civil justice system that we had graded. The result was that the court system indulged the litigants without any limit. On the day of the hearing, a case that was set down 6 months ago to be heard today, in the morning people come and say, Judge, we don't want to proceed. And my duty as a judge was to say, okay, well, which is the next date you want? Now imagine if that date was not occupied by those parties, that case could have been given to other litigants. So that is the importance you must appreciate when it comes to the new ethos of civil litigation that we are introducing at the High Court. Because that is the system you are going to enforce when you become a judge at the High Court. I must tell you a little story about a student who came from the UK, from the States, who was attached to the Deputy Judge President for about 3 or 4 months. I can't remember the length of time. Now, at the end of his stint with us, he came to pay a courtesy call on me and to say goodbye, and brought by the Deputy Judge President. And I asked him, what are your impressions about our legal system? And this is now an outsider talking about our legal system. He says, I am so surprised that the judges are always ready to hear a case, but the lawyers are not. That's what an outsider said. And that is the reality of the system that we had to change. So as I said, litigants were allowed to waste court time and resources, the delay being, the result being inordinate delays and incurring of costs, and the legal system was looking very bad in the eyes of the public. In the past, from the day that your case from the pleadings has closed, say all the pleadings have been finalized on Friday last week, you come to the registrar to look for a date, you would be very lucky if you got a trial date in the next 1 year. Usually it was about 2 years. That's how congested the court roll was. the court system was so congested with matters to be heard that those who have matters that can be set down today had to wait for 1 or 2 years in order to come to court. And then you have a case that has been set down a year ago, and on the date of the hearing, the people come and tell you they are not proceeding because they have better things to do. That is the culture we had to change. And judicial case management must therefore be seen against that backdrop. At the heart of the problem was the fact that it was the parties and their lawyers that determined the pace and intensity of litigation. And everywhere I went to benchmark on this problem before I introduced case management in the High Court, that was the issue. Botswana, who introduced it, Americans who did, the Australians who did, all the countries, or the Malaysians, the Singaporeans, all the countries where I went to study case management and how they introduced, that was what they say. You have to take control of the cases away from the litigants and place it in the hands of the courts. Because if you don't do that, delay is inevitable. And delay is not only waste of court resources, it means a lot of money for the litigants. I don't think you need to hear it from me to know that it is extremely expensive to litigate in this country, especially in the High Court. I always make the joke, I hope it is not an invitation to anyone to defame me, but I always make the joke that I hope nobody defames me because I won't have the money to go to court. And that's now your judge president talking. It will take a lot from me to go to a court to litigate in our courts. On average, if you go to a 2 or 3 day hearing in the High Court, say on a defamation case or a motor vehicle accident claim, you will be lucky. 2 or 3 days I'm talking about, if you pay less than $50,000. You will be very lucky. And that will exclude costs that you would have incurred before you come to the date that you get to have your day in court. Extremely expensive. Now look at the system which treats the public in that way. That they are strung along for a year or 2 years before they come to court, probably pay the lawyer $200,000 in between, and on the day of the court is told his case cannot proceed. And remember, the lawyer will always charge him for the reservation fees. So we had to do something about that. So remember this, the delivery of justice is too important to be left to litigants alone. It is not just a concern of the litigants, it is a concern of the public, it is a concern of those litigants waiting in the queue, it is a concern of everybody, the pace at which the justice system works. So I cannot say, look, I have a dispute with Thomas. Don't tell me about when and how I should finish it. Allow us to finish that case at the terms and in the way that we want. That is not acceptable anymore, because delivery of justice is a matter of public concern. Now, at the heart of our reforms are two important pillars that run through the reforms and the rules. And I want you to remember this always, so that you have it at the back of your minds when the other people come to talk to you about the procedures that we apply in the High Court. Two important pillars. The first was to clearly define the objectives of the system, or what it is supposed to serve. So a system which doesn't have any objectives is subject to being abused. So if you clearly define what you want to achieve with that system, we thought it will help the process. And that is contained in what we call the overriding objectives. I want you to study this very carefully, because I'm going to set an exam question on it. You must know what is the overriding objective of the civil justice system of Namibia. And look at Rule 1, Sub-Rule 2. I'll skip over to 3. Sub-Rule 3 is the important one. The overriding objective of these rules is to facilitate the resolution of the real issues. Emphasis. The real issues in dispute justly and speedily, efficiently and cost-effectively as far as practical, by ensuring that the parties are on equal footing, saving costs by, amongst others, limiting interlocutory proceedings to what is strictly necessary in order to achieve a fair and timely disposal of a cause or matter, dealing with a cause or matter in ways which are proportionate to the amount of value of the monetary claim involved, the importance of the cause, the complexity of the issues and the financial position of the parties, ensuring that the cases are dealt with expeditiously and fairly, recognizing that judicial time, and listen here, recognizing that judicial time and resources are limited, and therefore allotting to each cause an appropriate share of the court's time and the resources, while at the same time taking into account the need to allot resources to other causes, and considering the public interest in limiting issues in dispute and in the early settlement of disputes by agreement between the parties and to the dispute. You see, that captures it for you, everything that I have said so far. That litigants, when they come to the court, must not know that they are there to waste the court's time. There are certain constraints that you are placed under. One of them is resources. For example, I'll just take out one of them to highlight the point. Dealing with a cause or matter in ways which are proportionate to the amount of value of the money claim involved. Now, people come to court on a claim of $10,000. And they want to engage in the most expensive discovery process. Discovery is disclosing documents to each other. For example, the attitude I normally take is, why do you need such extensive discovery? Why do you need such complicated interlocutory process to solve a dispute which involves $10,000? And believe you me, if you have a claim of $10,000 you are pursuing in our courts, in the High Court, you are likely to pay $50,000 to get $10,000 back. That is the reality of litigation in this country. Now, what we are doing here is to guide the judge to say, when you are managing your case, use these guidelines to tell the parties, I cannot allow you to indulge in expensive processes to resolve a simple dispute, which is really about whether or not somebody owes you $10,000. That's the essential message we are conveying with the new rules. And that is the first pillar, as I pointed out to you, defining clearly what are the objectives of the civil justice system. The second pillar is to place the judge at the center of the process. That it is no longer the parties who will determine the pace of the litigation. The judge is at the center of it. It is the judge who guides the parties. It is the judge who prompts the parties. It is the judge who literally puts pressure on the parties to make sure that the case is completed as speedily as possible. And remember, always, practice direction. I will only refer to as PD, that's how we call them. PD 62. Those are your guidelines. Normally what I do when I'm managing a case, I don't do that often now, because I do less work in the High Court, is the first case hearing that I have with the parties, I tell them, do you know that this case is subject to practice direction 62? If it is a divorce, do you know that you are supposed to finish this case within 8 months? Do you know that? No, we didn't know, Judge. Now you know. So, today is the first hearing that we have. 8 months from now means, if we are in January or February, depending on where, it means October. Do you know that this case must finish with a judgment in October? Do you know that? Yes, Judge. I want us to organize all our things around that. That's how I manage my cases. So, if they come to me in the future, for example, with a postponement application, because this and that is not ready, I ask them the question, but how does that affect our disposal date? Will it not affect it by 1 month or 2 months? It will, Judge. So I'm sorry, I'm not going to grant you that. Because I have to make sure that I have to finish my cases within a certain guideline. Of the 5 cases, I think, which I was assigned beginning of this year, all of which had the disposal benchmark of October or November, I have only 1 left. Because I manage them in a way that I make sure, because you have to put pressure on them to comply with those deadlines, that if they are not ready, they know their claim is going to be dismissed. If they are going to come and ask for me for indulgences or postponements, they know I'm not going to grant it. So that's very important thing to bear in mind, that you are at the center of the thing. You don't allow the parties to come to you and say, Judge, how can you refuse us a postponement? We don't want to proceed with the case. As I'll presently tell you about another rule in our rules. It is not enough for parties to come to a judge and say, I give the plaintiff extension to file his plea. It's none of his business. You need the permission of the managing judge. You don't just agree between the two of you. So those are the 2 important pillars of the pillars that run through the reforms that we have introduced. Defining clear objectives for the civil justice system and placing the judge at the center of it, the system. There are subsidiary pillars which will become apparent as I proceed. For example, the rules impose a duty on the parties to cooperate between themselves and with the court to achieve the overriding objective. I'm sure those who are coming to make presentations will speak to you about it. And when they do, listen to that very carefully. There is a rule which says you are obliged to cooperate with your colleague in order to bring the case to finality. You are obliged to cooperate with the court in order to bring the case to finality. And that cooperation means at the earliest stage possible, you must identify the real issue in dispute. One of the things that we do these days, which was not done in the past, is in the first or the second hearing or opportunity you have to come before the judge wants to know, what are you really fighting about? You have drafted your pleadings 15, 20 pages long, with legalese and complicated, but what really is the issue between the two of you? That's what you want to know at the earliest stage possible. And it is their duty to help the judge to do that, to identify. And the judge will say, look, you tell me the real issue is the maintenance for the minor child. The issues you developed around who did what, who ran away from the home, who was not doing this to the other one, was not showing the other one not love or not. That really is not the issue. The real thing you are fighting about is maintenance. Now, why don't we concentrate our efforts on that? Why should I hear days and days evidence in order to determine whether your husband is a bad person? Why should I do that? If the real issue is what we want to determine is how much must the child get the maintenance, why should our focus be not that? That's how we should encourage them to avoid the unnecessary issue and concentrate on the real issues. So process is important, but it must not come at the expense of substance. Always make sure that you give sufficient opportunity to people to raise issues with you, to make representations, not in a complicated way, but just an opportunity to hear their side. But let process not overtake or take precedence over substance. And in the past, unfortunately, emphasis was more on process than substance. The so-called procedural rights. We have a right to amend. We have a right to file further pleadings. We have a right to do this. We have a right to do that. I mean, that's what the emphasis was on in the past. Not, is the real issue not whether you borrowed $10,000 from me, you say you didn't borrow the money, can't we find a most inexpensive way in order to resolve that issue? That's what it is all about. So the overriding objective in Rule 1, Sub 2 and 3, very, very important. Now, we have the objective clearly defined. Next was, as I said, to place the judge at the center of it. That is the phenomenon called the managing judge. That is your managing judge. What is a managing judge? We had to transform the role of the judge from a passive umpire to active manager, as I have just described to you. He is the principal, he or she is the principal enforcer, and there to make sure that the public interest is protected in the administration of justice. And remember the public interest that I have identified. The public interest is that cases must be finished speedily. That is the important public interest. The public interest is that the justice system must not become a joke. That is an important public consideration. The public interest lies in speedy finalization of cases. One case must not receive disproportionate time and attention than others. You must also look at the queue. The fact that 10 people are in court today doesn't mean 20 people will not come tomorrow to look for the time of the court. That's the important public interest. So the public interest is to make courts accessible to all, not just those who have pending cases in the court system. So sometimes people will be reluctant to come to court because they know, if I go to court, I will be in the court system for 5 years. I would rather not go to court. Now, once you have reached the stage where we are now, where an outsider comes and tells us, judges, you have become so efficient that you are always ready to hear cases, it's the lawyers who are a problem. It means the public interest is being served. That's the important thing about case management. Now, at the heart of all this is a system we call docket allocation. Very important. And remember, when the lawyers come to talk to you about the rules, docket allocation. Every case lodged in the High Court system is placed under the control of a judge. Now, if a case is filed tomorrow in the High Court of Namibia, through the e-justice system, randomly, that case is assigned to a judge. I just get a notice on my computer saying, JP, this case has been assigned to you. I don't sit and decide on a daily basis, this case goes to that one, that case goes to that one. It's a computer system that does it. That's e-justice. Of course, if there are specific cases that require personal attention, it will be brought to my attention. Say a constitutional case. That will be brought to me, and then I will decide, put judges so and so. But run-of-the-mill cases, judge just gets a notice on the computer, judge so and so, it's your case. And from that day until it is finished, that case remains under the supervision of that judge. That's docket allocation. So the judge is responsible for dealing with each and every step that arises in that case. So the judge has become the taskmaster to tell the parties what to do, when to do it, and how to do it. That is your managing judge. And once a case has been docket allocated to a judge, to the managing judge, it cannot be removed from that judge without the approval of that judge. So a case that is before Judge Parker, I cannot assign that case to someone else in the meantime, unless I call him in, we discuss why I'm doing it, and the system will in turn allocate the judge to the new judge. So docket allocation, case remains with you. And that case you cannot come today because you don't like Judge X. You come and say, look, in motion court, we are calling our case before Judge Damaseb because he's more lenient or whatever. It's not allowed. You can only do everything that you want to do before the judge to whom the case has been assigned. So the duty of the judge, as I said, is to ensure that the interest of the public is protected by making sure the matters are resolved speedily. What I have just described means that we have done away with this centralized system of allocation of cases. In the past, what used to happen is that the parties will litigate, they file their pleadings, they don't see a judge until maybe 2 or 3 years after the case is started. You don't have any connection of a judge, unless, of course, you have interlocutory things that come up which are put before a judge. That was the past. But today, especially in action proceedings, motions, different considerations apply. The moment you are a defense has been filed in a case, I file a claim against somebody, they have defended the case, immediately it pops into the computer of the judge decides when they must come before him or her to decide the process for how that will proceed. And that process will be described to you and explained to you during the course of the next 2 weeks, how that happens. So take good note of that. So the benefit of this approach is that the managing judge retains control over the file and manages and schedules interlocutory motions associated with the file. And you see, the benefit about that is that once you manage a case over a certain lifetime, over time you tend to realize which party is really not interested in prosecuting this case very speedily. Now, if it moved between 3 or 4 judges, that's very difficult to tell. You can take one chance with a judge, but it's difficult to take the second or third chance with the same judge. Because the judge will say, look, that's the same excuse you gave me last time. You are coming with the same excuse again. So keeping it with one judge really has the benefit that the judge tends to know not only what the issues are and what the dynamics of the case are, but you tend to know the behavior of the parties. Of course, we have built in a system where if there is a conflict, you can always return it to the registrar, and the registrar will then instruct the system to reassign the case to another judge. At any given time, the judges in the civil stream, and I now speak of action stream, will be managing about 250 to 300 cases you have under your management. So the research assistants who work with us help us to keep track of the cases, to schedule the orders, to make sure. It may sound very, very complicated and frightening, but once you get the grasp of what you are doing, it's not that complicated. So I want you to read carefully Rule 22 of the Rules of the High Court so that you get a very good understanding of what the role is of the managing judge. Now we have what we call the phenomenon of the residual court role. Now everything else which is not under the management of a judge comes on our residual court role. That's now the motion courts that take place on Fridays, Thursdays. On which days these days, Morgan?
It's on Fridays.
On Fridays only. That's not the only. The other one is the undefended matrimonial divorce. Yeah, but we have 3 motion courts. The one on Thursday.
No, it's first motion and second motion on Fridays, and then the undefended matrimonial is on Monday, and then the 108 also on Fridays.
On Fridays, okay. But again, somebody will be coming in to speak to you about how the motion court role is run. Only thing I want you to remember is that everything else which is not directly under the management of a judge is on what we call the residual court role. That's when you go into motion court on the Fridays and the Mondays that we talked about, where you grant in the undefended matrimonial divorces is, as the name speaks for itself, where you come and grant divorce after the people testify and so on, issue Rule 9. So where assets are being, where people's houses are being ordered to be sold, where default judgment is granted, that's on the residual court role. of the motion courts. I'll skip the stuff which other people are coming to speak about. In addition, we have something that we call the duty judge. Every week, there is somebody on duty. The role is prepared in a way that in advance you know when you are on duty. And the duty excludes your case management function. It excludes your case management function, and it relates to primarily the agent obligations. How do we assign somebody runs to court today, comes seeking agent relief? How is that dealt with? That's your duty judge. So every week somebody knows when they are on duty. And the judge will deal with agent obligations filed at the court, and there are special procedures for how that is dealt with, and that will be discussed with you during the course of the program. The managing judge has very, very wide powers, very wide powers. I've already made reference to Rule 22. I want you to look at Rule 18. Read Rule 18 very, very carefully. It shows you the powers that the managing judge has been given in order to achieve. Remember, in order to achieve what? The overriding objective, the public interest. Set out the specific powers, which are very, very extensive. Read Rule 18 in its entirety and understand it. Now, the powers that are given to the judge under Rule 18 are in addition to the other rules and other powers that the judge may have. For example, the court has an inherent jurisdiction to regulate its proceedings and to prevent an abuse of its process and to visit with contempt anyone who does not comply with its orders or violates its dignity. So read the powers that you have under Rule 18 together with the common law power that the court has, in common law inherent power that the court has to regulate its own affairs. So as a managing judge, using the powers that you are given under the rule, and in particular, before I say that, look at Rule 17.1 says, the rule instructs the judge in case managing to give effect to the overriding objective when exercising any power given to him or her under these rules, or in interpreting any other rule of procedure or practice direction. So the overriding objective of the rules is so important that even if you interpret another rule, what it should mean, you must always bear in mind the overriding objective. You cannot interpret a rule in a way that conflicts with the overriding objective. If the interpretation of it means that the overriding objective will be defeated, that is the interpretation that you must avoid. So the managing judge will therefore be expected to keep a very, very close eye on the following aspects of the case. As a managing judge, these are the things that every day you are looking at. The way the pleadings are being exchanged, and you would have made orders which will guide that process. They will come and speak to you about how that works. You are going to supervise the discovery process. If the party wants a document from the other party, you want to know why they want it. Why do you want a document which doesn't add anything? I mean, if what we are fighting over is $10,000, which I say you owe me, why do you want to bring an obligation to require me to disclose things which are unrelated to that issue? So you have to monitor our discovery process. You must always make an accurate assessment as to the possible court time needed for the trial or the hearing. You know, the moment I get a case, my first concern is I begin to ask myself the question, how many days do I need to finish this case when it goes to trial? And I keep engaging the parties on that. Always, always keep your eye on that. You have to already start planning for the trial date. You must look into the bigger picture always. And make sure that you limit as much as possible interlocutory processes to what is necessary. I tell you, 80% of the interlocutory obligations brought in the court are unnecessary. They are just intended to waste time and to buy time. Now, what I did very recently to deal with that problem is that I've introduced a new directive which tells the judges, don't write long judgments. If people come and say they want an amendment, they want discovery, or they want to do this or other, postponement, even application, we introduce a system of abbreviated judgment. You refuse or you grant, and you, in bullet form, 4 or 5, you just tell them, I refuse that because I think you did not make out the case, you are wasting time. You can give whatever reasons which are suited to the case. So we have introduced another mechanism to help the judges not to spend too much time on this matter, so that by the time they finish arguing the interlocutory application, if possible, let them get the result the same day. Let them get the result the same day with your abbreviated reasons. One other important feature of this, therefore, to explain all that I have said, we no longer have something called postponing cases sine die in the High Court. You can't come to the High Court and say, we have postponed the case, Judge, or we want you to postpone the case sine die to a date to be arranged with the registrar. It no longer exists. There must always be a next event in every case. Very important for case management, because the moment you fail to do that, you have lost control of your case. So parties appear before you walk out of court. Always make sure when is the next date for the case, and not only that, they must know what they are coming to do with the next date and what they should have done in the meantime to prepare themselves for the next date. Very important. That's the way you keep the case under strict control. It has been said that in a judge's case management function, there is very little that a judge cannot do by way of case management, and that the managing judge's power of managing a case is circumscribed only by the constitutional imperative of a fair trial and having one's case determined by an impartial tribunal. That's how important case management. Now, there are important tools that you have at your hands in case management. How you can make sure that the case is always moved from one stage to another. Two important ones. One is costs, cost orders, and sanctions for non-compliance. So during the course of the program, listen very carefully to the presentations that are being made on those issues, costs and sanctions for non-compliance. A cost order can be granted against a non-compliant party, and that is the customary weapon in the court's arsenal to enforce compliance with rules and court orders. So if people don't do what you have ordered them to do, next time around, impose cost, grant cost against them. There are circumstances in which judges have refused to grant you costs. For example, somebody comes to the High Court to issue to pursue a claim for $10,000, which should have been issued in the magistrate's court. We refuse them costs. We say, no, I'm sorry. You should, constitutionally, I cannot prevent you from coming to the High Court, but tough luck. You should have brought this case in the magistrate's court. The High Court is busy as it is. I won't grant you costs. If a party has not done something on time, next time around, consider to impose costs. And again, the second one, important one, sanctions for non-compliance. Sanctions. You'll hear a lot about sanctions during the course of these 2 weeks. How do sanctions work? In our rules of court, the reforms that we brought in the rules of court is that if you don't do something by a date prescribed by the rule itself or a court order, you are automatically in default. So if I didn't file a plea, the judge ordered that I must file a plea on the 20th of November. 20th of November comes and passes. What that means is that in order for me to be able to file that plea, I must come back to the court to seek condonation or extension of time. That was not the case in the past. All you needed to do, if you didn't file your plea by 20th of November, is to come and say, no, I agreed with the other side that I will rather file it in December. That's not possible anymore. So if you didn't file your plea on the 20th of November, and you don't ask for the court's indulgence, your claim is, your defense is dismissed. Ipso facto, you are barred ipso facto. If you don't do something by the time or the date by which you should have done it, you are barred ipso facto. Which means you can no longer pursue that remedy unless you have the permission of the court to do so. Very important provision in our rules, which didn't exist before. Of dismissal, this is important, I want you to make note of it. The ultimate sanction of dismissal must be used sparingly and only where it is clear on the record that the delay was unreasonable, or what we call in legal jargon, contumacious conduct. I want you to, okay, I'll give you a reference to an American case. And that approach was adopted by Judge Gaya in the case of Namibia, Namhila versus Johannes. It's a then unreported judgment, 28 January 2013. Its neutral citation is square brackets 2013, NAHCMD 50. That would mean Namibia High Court Main Division. I'm sure you are familiar with reading our judgments, the neutral citations. Very important judgment. So just remember, it's a very drastic sanction is to dismiss somebody's case. So use it sparingly, and only when you are satisfied really that their conduct was very bad and unreasonable. How do we measure the effectiveness of a managing judge? That will depend on your ability to get the case ready for hearing within the timelines set in the case plan order that you are going to give. We will come and speak to you about the case plan, including the timely dismissal of interlocutory motions. That's how we measure you, one way we measure you. And you must ensure that the case does not stall or lie dormant, and identify early enough the real issues in dispute between the parties, and to fashion your case management orders that speak to the issues in dispute. Another important attribute of the powers of the court under the new rules, the court may act of its own motion. You don't always need to be asked by the parties to do something. The judge may act of his or her own motion, not always at the prompting of the court, parties. And that will be Rule 18.5. Look at Rule 18.5. And as I said, always giving the parties the opportunity to make representations. But if you are concerned about something, sufficiently concerned, that you want to do something about it, tell them. I normally will issue an order to say, I want on this day for you to come and address me why I should not dismiss this case, or something to that effect, giving them the opportunity, even if I have not been asked by somebody. So you can act of your own motion. And that is an important realization that the judge is no longer a passive adjudicator of the old. Another important attribute is which the one I have already mentioned, is that the relief must be sought by a non-compliant party. If you have not complied with deadlines of court orders, you must come and beg the court. That's what it simply means. And what do you do as a judge when they come and do that? You are guided by their overriding objective. Always. So in that respect, I want you to look at Rule 54.1. Look at Rule 54.1 about when the parties have failed to do something and they must come back to the judge to seek the condonation or extension of time. Another important attribute is parties may no longer indulge each other in certain situations. I mentioned that to you before. I want to deal final issue. The judge's role in civil proceedings. This is very important if you come and work at the High Court. And I want to deal with this issue specifically because now and then we get this problem, even amongst experienced judges, and the Supreme Court has to put it right now and then. So it's important that I mention it to you. Although not confined to civil proceedings, the rule has developed that the court must decide constitutional issues only when it is absolutely necessary. So if people come and say this is unconstitutional, that is unconstitutional, but you think the issue can be decided on a basis other than a constitutional basis, that is what you must do. I want you to look at the Kawesa judgment, Kawesa versus Minister of Home Affairs and others, 1995, NR 175, Kawesa, 1995, NR 175, Supreme Court judgment. And it was expressed by the Chief Justice recently. No, not recently, but in 2011 in the case of Namib Plains Farming and Tourism versus Valencia Uranium. You'll get the references. 2011, Volume 2, NR 469 at 483. I'll give you a reference. The role of the judge in a civil proceeding differs materially from that in a criminal case. For example, in a civil criminal case, the magistrate can call witnesses, isn't it? Civil case, you cannot call a witness. Very important difference. You can only do that with the consent of the parties. If you feel that a particular witness may be important to resolve a certain issue, don't impose it on them, ask them. Don't you think it will help us to resolve the issue more speedily if that witness is called? And if they say yes, then you can. If one of them says no and they are refusing, don't call the witness. But the other party may get the hint from you and subpoena the witness anyway. So don't go around calling witnesses on your own. A judge in a civil case may not rely for his or her decision on matters not put before the court by the litigants. So don't go and decide issues which the parties have not placed before you. Now and then, unfortunately, it happens, but don't do that. As much as possible, confine yourself to the disputes and the issues that, and in the manner in which they have been framed, that were put before you. But if a judge considers it to be material to the outcome of the case argued before him or her, invite the parties back and say, look, you have already argued this case. I have considered it. I have a feeling that in order to address and to resolve this issue, this is the issue that needs to be addressed. Can you give me submissions on that? That you are entitled to do. But don't, as the Chief Justice calls it in the Valencia case, don't go on a frolic of your own to decide cases as you please. And particularly when the cases, the issues have been limited by the parties themselves. And case management does that, and you will be told how that works and the rules. The pre-trial stage, the parties will tell the judge, these issue 1, 2, and 3 are the issues that need to be decided. That's how they have limited them and confined them. Your task first is to make sure you hold them to those issues, that you do not decide or raise issues other than those that have been properly recorded in the case management order. Secondly, you cannot go outside those issues as a judge. They are very, very important. So, that is what I wanted to share with you this morning.